Let's talk about copyrightable subject matter. Probably helps to start with a statute. So 17 U.S.C. 102 says subject of copyright matter in general. There's two provisions, or rather subsections of this. But what do these do? Well, A provides the basic test. Copyright exists in original works of authorship fixed in any tangible medium, whereas B is talking about what is barred. We're going to focus on 102A, what is copyrightable. Now, the first thing is, are these things listed, 1 through 8, the only possible things copyrightable? Well, the statute actually tells you. If you look at it, it says works of authorship include these categories, which means these are not the only possibilities. You might be wondering then, why bother listing any at all? Well, it helps to have some examples, plus it actually does make a difference sometimes what the category is in terms of the scope of protection. And actually, for one category, pictorial, graphic, and sculptural works, what is protected can be a little bit different. There are different issues that's a little bit more complicated. But let's stick to the basics for now. So, we've already said not all listed works, or actually, we didn't say this. The next question is, are all listed works copyrightable? And the short answer is no. How do you know that? Well, the image of the phone book is supposed to be a reminder. A reminder of what? Well, it's a reminder of the Feist case, where the Supreme Court said that although a phone book is a literary work, it doesn't pass the actual test. So remember, these are examples of categories that could be copyrightable, but they still have to meet the two-part test. The test is that it's an original work of authorship and that it's fixed. Is effort relevant? i.e., if you spent a lot of time putting all those names and phone numbers together trying to find out those informations? Short answer is no. In the Feist case, the Supreme Court said the so-called sweat of the brow doctrine does not apply to what's copyrightable. You need an original work of authorship. It also, of course, has to be fixed, but the phone book is clearly fixed. It's not changing. But the question is, how do you assess whether a compilation of material, such as a phone book, is original? Well, basically, the Supreme Court told us that it has to do with the selection and arrangement. So, if your selection and arrangement is completely ordinary, then that's not particularly helpful. And that's why the phone book was not copyrightable. However, if you come up with a highly unusual way of arranging names in a phone book, so for example, a phone book that was phone numbers for law students by graduation year, by pet they own, by home state, that might possibly work, but not what we all expect a phone number to look like. Now let's keep talking about copyrightability. Again, this is the basic test, but what do we mean when we say original, besides for compilations? Well, basically, original means original to you, i.e. you didn't copy it from someone else. It's pretty low threshold. Do you have to use it in commerce? Short answer is no. You can have copyright as soon as it's fixed in a tangible medium. Now, what's in the Copyright Act versus case law both apply to copyrightability. The Feist case we just talked about adds a gloss, a judicial gloss, to what's an original work of authorship. But sometimes the statute provides definitions, such as what is fixed, tells us it's permanent enough that we can perceive it. And also that this can apply if a work is being transmitted at the same time it's fixed. This might happen, for example, with a sports game that's being transmitted on TV while it's also being recorded. The last issue that we're going to go over is whether you have to have registration for a copyright to be valid. Short answer is no. Registration is not required. Of course, there are benefits to registration. In particular, if you do so within 5 years of publication, there is a presumption of validity. In addition, even if you don't register within the 5-year time, if you want to actually sue for copyright infringement in the US, you do need to register. Now, if you're going to register, you might be wondering, with whom? Well, it's actually with the Library of Congress, which may not seem intuitive, but that is the entity that you want to approach for copyrightability. Different than if you want to obtain a patent or to get certain benefits for a federally registered trademark. For those, you would go to the Patent and Trademark Office. Hopefully, that was a helpful overview to basics of copyrightability.